Any mention?
May I please, Your Lordship, I beg to make a mention on part 2 of the hearing, this item number 27 and 28, Your Lordship.
Yes.
27 and 28. In 28,
Why?
I have to file this affidavit to bring on record the Home Guard
Why?
recruitment policy. I have to
Your
file
file
an
report,
additional...
was it allowed by the court last time?
Yes, Your Lordship, as per order dated 21st September 2023.
If you say so.
I'll be filing during the course of the day. I could not self-complete.
27, 28.
27, 28, yes, Your
Mr.
Lordship.
Abraham submits that the affidavit as allowed by order dated.
21st September 2000.
Order
21st
order
September
dated
2023.
21/9.
21/9, yes.
2020 will be filed in the course of the day. He pays the matter be taken after
After a week, after 2 weeks, Your Lordship.
after 2 years. Prayers allowed this after 2 weeks. Yes.
Hello, Your Lordship.
Yes.
My please, Lordship. Item number 16, my Lord, is relating to transfer cases from the normal court to the district council court.
16 to?
My Lord,
19.
item number 16
Yeah,
to
let's do
19,
these
my Lord.
cases. When should we do them?
My Lord, so it's a request, my Lord. I can see Leonard
Where's the EG?
My lord, he is
EG and,
available.
NG
He is in
also.
court number 1, my lord. He is here today.
No, I mean, let us fix the date that you don't take
my
adjournment.
Lord.
Yes, yeah.
Right, right.
Fix another date.
Lord, he
With your
fix
permission.
after 2 weeks, all the lawyer comes and I'll
Yes.
put the case and
No,
finish.
take a fixed date. I think
My lord, otherwise, AG is ready today, my lord.
other
He has
cases,
come
I
for
think
this
it's
matter.
stuck on criminal appeals, yes.
He has actually fixed today, my lord. On the last occasion, Lordship is aware that AG has asked for today's date, my lord. It was agreed.
Is the matter fixed, my Lord, next week? Or after 10 days, my Lord?
After 1 week, just...
After 1
yes.
week. We'll inform the Leonard
16 to
20, my lord.
To 20.
4 matters. Okay.
4 matters are just together.
Yes. Highly
5, my lord. It's
Right.
5
on the prayer
matters.
of the parties, yes.
5 matters, my lord.
It's understood. It is expected next date, no further adjournment
Yes.
will be taken, yes.
Right.
Yeah. Yes, Mr. Rishi.
Item 22 to 26, that continuing matter.
Mohammed Tayyib.
Tayyib.
Let us finish this off also. Where's
Yes, we'll
Mr.
fix the
Manta?
next date only. I've
You
taken the
have no
consent.
case.
No, there is only one point to be decided.
There's no point.
It's Section 185 of the Contempt Act.
When there's no point continuing adjourning also. Sixteen matters. Take a fixed date. No more adjournment. Where's Mr. Manta's
No, Mamta,
party?
I have taken his consent. He said just ask 3 weeks time.
1 week will serve.
2
1
weeks, after 2 weeks, Lordship.
week. 2 weeks, the last, this matter of 2 weeks no, this matter has been adjourned repeatedly on,
We'll finish it this time.
okay. It's expected next week, no further adjournment will be sought. Yes.
Much less.
So tell these juniors what the matter is being mentioned, they should be here, they should be know what matter they've come to appear for, yes?
I beg to mention item number 32, Your Lordship.
32.
Yes. Let it come after 2 weeks.
Why? What's 32?
Your Lordship, my senior is out of station, Your Lordship.
Who's for the...
My lord, even the conducting counsel for the said Mr. Karumalang is not well, my lord. He's indisposed.
Okay, after 2 weeks, yes.
All right.
May I please, Your Lordship? Your Lordship, I beg to mention item number 30, Your Lordship. I pray if this matter can be taken up after 3 weeks, Your Lordship.
No objection?
No objection, Your Lordship.
2 weeks, okay.
3 weeks, Your Lordship.
2 weeks, yes.
May it please Your Lordship, I beg to mention item number 31.
30?
31.
Who's on the other side?
And for the state, Your Lordship.
Dr. Mozika.
Take up
What's the matter about?
the house constructed by the river, house constructed by the Mintru River, which,
Or is that Mr. Shongwan's case?
yes, Your Lordship. The conducting counsel is having some personal difficulties.
Okay, after 1 week?
2 weeks, Your Lordship.
Okay, 2 weeks, yes.
Of like Lordship.
May I please, Your Lordship?
Yes.
I beg to mention item number 34 and 35, Your Lordship. I humbly pray that this matter be taken after 2 weeks, Your Lordship.
Why?
Need some more time, Your Lordship, to prepare. We are not ready, Your Lordship. We need some more time to prepare.
Who's not ready? You? Where's Mr. Deb or Mr. D?
They are still on leg, Your Lordship.
Okay, 2 weeks, but don't take too much time. Is and again, yes,
Much obliged, Your Lordship.
yes.
Daily list item number 1.
I think
Yes, Mr. Das.
termination, they have terminated this contract now.
Terminated with contract.
Termination. Initially, the earlier writ petition which was filed before this Honorable Court was regarding about the contract doesn't survive. That's what they said. 24th of April 2022. Then we have filed a representation before them.
No, what happened? No, what contract is this?
Contract is about the Hydel project, my lord.
Okay.
Where's Kasi Hill?
What
That particular, my lord, project was given to us by letter of intent. 2 preliminary
That was
agreements.
in
2014.
okay.
2014.
Yes.
Now thereafter, my lord, within 48 months from the date of preliminary agreement, we have to submit DPR. So 2015, before 48 months, we submitted DPR. Before the authority, they kept quiet. On 9th of February 2020, there was a MINUSOM meeting. Certain proposal was given to them, but we have not heard. It is a part of the annexure. Thereafter, when we have not heard from them, on 9th of February 2020, when MINUSOM meeting was held, then on 24th of April 2022, my lord, they decided to cancel it, and that's on the ex parte.
Well, that was the earlier
Yes,
petition. Yes,
cancel.
I remember now, yes.
Now they cancelled it, my lord. Then we represent matter twice before them, the cancellation. We have written to them, we want to settle, we want to sit with the government, we want to resolve the issue. But on 9/9/2023, my lord, they have written to us and they said that this was done because technically it was viable, but financially it is not viable. Tariff which was given a higher. Again, we represent the matter, but in the meantime, we came to know from them through Facebook and Twitter, they want to bring some other parties and enter into some partnership agreement with them. So we came up before this court. The court has issued the notice. My learned friend also appeared. Some objection. No, they raised an objection regarding maintainability. Okay. They said that writ petition is not maintainable on 4 different grounds. We have filed a reply also on 8th of February, this February. In the meantime, on 22nd of December 2023, when the matter was sessioned, they decided to terminate our contract. So that also arose a different cause of action.
They terminated the contract, I mean the other one entered in 2014.
Yes, now they terminate the contract of 2023, they terminate the contract. Now the scenario...
Where's that impugn order?
Yes.
176.
Now, kindly, my lord, if your lordship is not inconvenient, your lordship, kindly see 157, then I will show it, my lord.
Of course.
157, my lord. Yes, yes. That was the first writ petition which was filed. Then I will show this 157. 157.
Yes, 157.
So, my lord, so and so assisted. Interim prayer, if any, shall be taken up for consideration on next date. Now, next see 158, my lord.
Yes.
So, Kumar learned AG for response submit as the contract has come to an end in 2015. No further vested right accrues to the writ petition. The matter involved disputed question of fact. Counsel, ECO leaves this matter for admission or reopening. 159. In the meantime, any further action or response will be subject to further order of this court. Now, this was the order. Now, my lord, 176 INDC, your lordship was asking about how they have dealt with and terminated. The contract is 22nd of December 2023. 22nd of December 2023. Received, my lord, we received on 24th of January 2024. That's a statement we made. Ultimately, my lord, see, this is termination. There is no question of staying a termination which has been terminated by them. Your lordship has to examine this matter. Now, their stand. Now, they have relied on all the...
Said, yes, termination
I'm sorry.
Agreement.
Yes.
Dated 9/5/2014.
Yes. All the preliminary agreement, they have mentioned all the preliminary agreement. Now, if you see, of course, it will be a matter of admission hearing. If you see the preliminary agreement, all preliminary agreement consists that before they take an action, they have to give a principle, they have to hear us, which has not been taken. Now, absolutely it has now reversed because of this termination order. Now, the stand which they have taken in the preliminary objection regarding maintainability.
What's the reason?
The reason said, my lord, kindly sir, I have failed to perform under the preliminary agreement. All those reasons were given. 177 kindly be 176, 177, my lord will kindly say. 177 bottom. Now, therefore, in view of the above facts and excess of power on the various clause 29 of preliminary agreement is reiterated the preliminary agreement no longer in existence. The said aspect hereby informed to you by way of an abundant caution. That it is further informed upfront fee paid by is also sent forfeited as per clause 4 and 8 of preliminary agreement. Inform that you are not entitled to claim any further amount of preliminary agreement. So, your lordship, what I subject to your lordship, what your lordship says. So, your lordship will examine this matter. My lord, what we are trying, my lord, there is, we want, my lord, our client said that they met the government official, they want to sit together. And if it is, my lord, as a particular solution comes to, it's better, my lord. I told my client, why don't you sit and try to resolve the issue? So what I propose, my lord, subject to your lordship approval, and what my learned AG says, my lord.
One thing Mr. Das is saying that the earlier way they have said that it has lapsed or something, right?
Yes.
That is, now you mean to say that in terms of this new termination, they referred back to the agreement.
Yes. Now that's completely...
From the order which I saw that as submission that no right no longer accrues. I mean, there's no right, no...
No, that's why, Lord, earlier what they said, that your contract is no longer in existence because of 19. Now kindly...
On terms of contract, they have terminated.
Now the terms
Yes,
of contract...
sir.
Yes.
Yes, my lord. In terms of contract, I have terminated.
Yes.
Your lordship, kindly see the impugn order. It is a self-contained order, my lord. And I will read this order very slowly, my lord. Paragraph 1. Whereas the captioned preliminary agreement was executed between you and Government of Meghalaya for survey of an investigation of Upper Cree Stage 1, 15 megawatt and Stage 2, 10 megawatt in Meghalaya on boot basis, build, operate, own, transfer basis, my lord. Whereas the total amount of upfront fee required to be paid is 125 lakh, but you have paid only 118.7 lakh, showing a failure showing a failure to pay the full amount after a gap of more than 10 years. This upfront fee stands forfeited as per clause 4 and 8. Whereas you have failed to reimburse the government and appropriate state power utility 50% of amount spent by the government on investigation and infrastructural work and project totaling to 1 crore 45 lakh and 72.59 lakh as per clause 16 of preliminary agreement. Whereas clause 9 of the preliminary agreement requires certain milestone to be achieved by you, and you have also failed to achieve the same despite numerous opportunities to given to you. Whereas the appraisal report of detailed project report dated 13 December 2015 of the above two projects weighted by MEPGCL showed that projects are not financially viable with a tariff cost of 9 rupees 30 paisa for so and so and 8 rupees 18 paisa for so and so project. Whereas in terms of clause 12 of the preliminary agreement, it is clearly stated that preliminary agreement shall be valid up to a period of 1 month after due date of submission of DPR or signing of implementation agreement, whichever is earlier, my lord. Your lordship kindly mark that it has to be within validity is 1 month of submission of DPR or signing of implementation agreement, whichever is earlier. In terms of clause 12 of the preliminary agreement has come to an end within the 1 month of submission of DPR, that is 12/1/2016. Therefore, preliminary agreement is not in existence today. Because, my lord, there was no implementation agreement signed between the parties, my lord. There was no implementation. Where in terms of clause 13 of the preliminary agreement, liberty was given to both the parties to enter into implementation agreement only when both the parties are satisfied with techno-economic feasibility of the project. Whereas the government of Meghalaya is not satisfied with techno-economic feasibility of agreement, therefore it is at liberty to not to enter into the implementation agreement. Whereas you have placed the proposal of minutes of review meeting, etc., my lord, and then there is a seeking on 19 February, waiver of additional 10% free power to government offered by you during the bidding process over and above 12% free power to government as per state power policy. So they wanted some waiver, Miller, to include the development of approach road and other infrastructure facilities other in the state budget to relieve the developer from financial burden, to waive of charges for hydrometeorological data to be paid by developer for receipt of said data from MEPGCL for formulating the DPR of the two projects, to take into account additional power that will be generated by down downstream existing Umiam 4 and MEG PCL account of diversion of Upper Cree River from two projects to avail soft loan from MIDC against the project since banks are reluctant to extend financial support for hydro projects, whereas the said terms and conditions are not acceptable to the government and also amounts to post-tender modification and are also not in public interest, whereas you have also shown complete apathy in pursuing the matter in right earnest, which led to inordinate delay in implementation of the project, and you have also failed to attend review meeting on so-and-so date. You have also raised an artificial and fictitious bogus claim of 15 crore, where a state has suffered loss on account of your acts and omission. You have no basis to make the above claim, where a state is entitled to be compensated for losses caused by you inordinately delaying the project and submitting the defective DPR, not making the payment in terms of preliminary agreement. Now, therefore, in view of the fact exercise of power under clause 29 of preliminary agreement, and it is reiterated that preliminary agreement is no longer in existence, said aspect is hereby informed and by way of amended caution. There, it is further informed that upfront fee paid by you also stand forfeited as per clause 4 and 8 of preliminary agreement. That is further informed that you are not entitled to claim any further amount on preliminary agreement arising out in relation to lapsed preliminary agreement of 9/5/2014. The instant order is being issued in accordance with preliminary agreement dated so-and-so and without prejudice to rights and entitlement of government of Meghalaya in accordance with law. My Lord, this order is under challenge before your Lordship in the instant writ petition, my Lord. Now, the preliminary agreement has come to an end, my Lord. There is no dispute about it. There are certain claims which the petitioner is having on the state. A state is having certain claims against the petitioner, my Lord. Public interest is, my Lord, that this project is of 2012. It is not moving single inch forward, my Lord, my Lord. So therefore, whatever process we have to follow in accordance with law, my Lord. And if I have seen the writ petition, my Lord. No, if your Lordship will see the ground of challenge, my Lord. In the ground of challenge, there is nothing to say that all these are commercial terms and conditions. And they, in paragraph 11, page 11, paragraph A, my Lord, what is being said is that impugn is arbitrary, illegal. They are not saying whether I am entitled to terminate. Those clauses which I have invoked can be invoked or not, my Lord. So therefore, in these matters, I can file a short reply, my Lord, if you like.
Short reply, take up for division hearing. We'll dispose of next date.
In the meantime,
actually, because if realm now becomes more and more constricted into contract.
yes, I know. I will satisfy your Lordship, my Lord. Now,
that point.
my Lord, my case was okay till my Lord, they would not have terminated. Now they have terminated the contract. Now termination of a contract goes back to the preliminary agreement, which they have taken after 10 years, my Lord. Your Lordship will keep it in mind. Because they said their contract doesn't survive. That particular matter.
This kind of,
I will satisfy. No, that my Lord, my learned friend,
there's been hostile explanation against you. Otherwise, anyway, Mr. D. Das Leonard, Senior Counsel for the petition assisted by so-and-so. Stop issue notice. Mr. A. Kumar Leonard, Advocate General, present with so-and-so for all the respondents. No further notice called for. Stop. Mr. A. Kumar, Leonard AG for the respondents, please for 1 week's time.
2 weeks time.
2 weeks.
1 week will be too tight.
That's what I was saying to my learned friend.
Yes. 2 weeks after to please for 2 weeks time to file short objection to the maintainability of the incident petition. Maintainability.
My only one request, a humble request before Lordship, pending will not be a bar to discuss with the government, because I know that's will
okay.
We'll have a word with the government.
On the maintainability of the writ petition, stop. It's for provided that this petition shall not be a bar to the parties coming to an out-of-court settlement. Yes.
My Lord, this will tag with item number 4. Yes, tag with it.
List together with item number 4.
After 2 weeks, my Lord. One date if I...
Date you can take.
Yes, I am deeply convenient. Yes. Deeply obliged.
Item number 2.
Please, Lordship. Lordship, this is a very peculiar...
Where's your Mr. Kanta?
Please, Your Lordship. Your Lordship, we're not in this matter, Your Lordship. It's supposed to be taken up by Mr. T. Ding Do.
Who Mr. T. Ding Do?
Mr. T. Ding Do, Mr. Themis Ding Do.
Then what can we do? Is motion?
We already serve copy to District Council, Your Lordship.
The endorsement, Your Lordship, it's endorsed to them, not to us, Your Lordship.
I'd like to move, Your Lordship. We'll ask
Move, no problem. Yes.
Lordship, this is a very peculiar case, Your Lordship.
Clear case of?
Very peculiar case.
Oh, peculiar case.
Yes, Your Lordship. Wherein my objection.
Why is it peculiar?
Wherein my objection has been rejected, Lordship. I've objected to the nomination paper of one candidate, election of Serdar in Elaka Nongjri. My objection has been rejected on the ground that I have not filed my written argument.
Why you didn't file an argument?
I filed, Lord.
Where is it? It's on record.
It's on record. So on that basis, Your Lordship, the
That
objection.
means that objection to whom? To a candidature of certain person?
Yes, yes, yes.
You
That,
objected.
We
and
objected
there was
before
proceedings were taken up.
Yes, before returning officer. Returning officer, exercising the power under Section 4 of the Act, Your Lordship, has referred it to the EC. EC conducted preliminary hearing. We participated in that. EC directed us to file written argument.
What are your objections to a candidate?
There are certain aspects, Lordship.
Is he convicted criminal?
No, we have raised some objection, Your Lordship.
But on what grounds can a person be, disqualified from contesting office of Sardar?
Because there is a provision, Your Lordship, that under Section 11 of the Act, which says that.
What does it say?
It says that a person, once he leaves office as a Sardar, he is supposed to return all the papers. Whereas this person who's contesting now, he's an ex-Sardar, he have not returned the papers.
Where have you said that? What Section 11?
Section 11 of the Act of 1959, Lordship. But that apart, Lordship, because the...
Let me see whether that those exist or not.
Yes, yes, Lordship.
Is there?
It's there, Lordship.
Which page is it?
United Khasi Jaintia Autonomous
I'll
District.
get confused with this.
Appointment and Succession of Chiefs and Headmen Act 1959, Lordship. Section 11. 11.2, Lordship. 11 clause 2.
It'll be in part 2. Huh?
Yes, sir.
Yes. Section 11.
Yes.
Okay.
Subsection
11,
2. Subsection
11 upon acting chief.
Subsection 2, Lordship. 11 subsection 2.
Whenever the change incumbent account of subsection 1 is acting,
there shall be a proper taking and hand over charge of office, properties duly recorded in the writing
whenever
between.
the change incumbent account of subsection 1, there shall be present. But it's acting only.
Yes. Because what has happened, Your Lordship, initially I was appointed as acting. He was removed. The private respondent was removed. I was appointed as acting. And at that point of time, Lordship, he did not hand over the papers. So now when there's fresh
What
election...
papers are so important he has with him?
Because for running into administration of the Elaka, Lordship. But that apart, Lordship,
Why?
since
He's very popular.
No,
This is your respondent number 6. You're scared of him.
not that, Your Lordship.
You're a contesting candidate also.
Yes, Your Lordship. But that apart, Your Lordship, since the merit is before the executive committee, I'm before this court just on a limited ground, Your Lordship. Since I have filed my written argument and they have said that we have not filed written
Where
argument.
did he say you are not filed?
I'll just stick to the impugn order, Lordship. Page 84, Lordship.
Yes.
Last page, Your Lordship.
Is Beul's son Mokon?
No, Lordship.
And the two nomination papers don't do one.
The third paragraph towards the end, Lordship.
Okay. However, all the complainants fail to submit the written argument as directed even after the expiring of the date fixed, that is 25/11/2023. Whereas both Shri so-and-so and so-and-so were prompt and submitted their argument dated 22/11/2022. The matter was taken up and considered the written argument of both so-and-so and so-and-so dated so-and-so, who retreated their stand denying all the allegations made by the complainants against them. Further, considering the fact that all the complainants have failed to comply with the direction for submission of the written arguments, it appears that they are no longer interested in the matter. And in view of the same, Your Lordship, they were allowed. When is the order dated? When?
This order is dated 25 January 2025.
Has election date been fixed now?
No, Lordship.
You're sure about that?
Yes, Your Lordship.
Heard Mr. Njay Shilla also issue notice of, as it is reported that
a different standing counsel has been engaged for an instant matter. Petitioner to ensure that copy of the petition is made over to the respondent. So also stop. The grievance of the petitioner is that this executive committee, respondent number
2, Lordship.
So 102, by order dated 25th January 2024, had had in a pending proceeding with regard to the objections of the petitioner to the candidature of
Respondent number 6, Lordship.
Respondent number 6, close the same on the ground that written arguments by the petitioner had not been filed. Stop. Next, Mr. Jishra submits that this finding is incorrect inasmuch as the set written arguments in the set proceedings have been filed. And as such, the impugn order being bad or being illegal is liable to be interfered with. Seen the impugn order dated 25th January 2024, it is noted that it is recorded therein that the complainant, one of the complainants, noted therein the complainants failed to file an arguments as directed. And the returning officer, Khasi Logistics Council, was hereby to take further action to complete the election process of the Sardar Nongjeri Eleka at the earliest. Stop. As there is no representation on the part of respondents today, list this matter after 1 week.
1 week. Stay of this impugn order.
And for 1 week. In the meantime, the impugn order dated shall not be given effect to. Yes. You say you filed it, the impugn order, because a very small offshoot. I mean,
yes,
if the standing counsel was here, we could have finished it. Oh.
Yes, Lordship.
Item number 3.
Obliged, Lordship.
Please, Your Lordship, I would like to apologize, Your Lordship. We cannot file a rejoinder, Your Lordship, due to the loss of contact, Your Lordship, with the client.
You don't know the client anymore. We'll dispose of the
matter. We
matter.
try to contact them, Your Lordship, but they are not. So
we will close the rejoinder then.
Yes, Your Lordship, we will proceed with the hearing, Your Lordship. We will not file.
I just need to bring one short document on record. Communication which we've received from the CM of Milliam asking us to keep the Section 8 proceedings in abeyance. I'll just bring that on record.
What Section 8 proceedings?
The petitioner had filed an application for eviction of the private respondent under Section 8 of the Land Transfer Regulation Act. They claim that the transfer is illegal. So while we were proceeding with the Section 8 proceedings, they've issued a letter that they are adjudicating this entire dispute and we should keep our proceedings in abeyance.
Who informed you?
The petitioner. He's filed a complaint. That complaint is at page 42.
No, that is being taken before whom? Before Milliam?
No, before the DC. Under the Land Transfer Regulation Act.
No. You have to keep in abeyance what proceedings?
So CM has requested us. CM claims, the same of Milliam claims that there is some adjudication
that since the matter is taken by CM Milliam.
Lordship.
You don't need to file a thing for that.
Just that document, I want to bring it on record. If Lordships permit.
When was the document given?
22.
And he's come on 23.
23.
So he's alleging that you have not taken any steps on Section 8.
Lordship.
Okay, Mr. Essence submits that praise may be allowed to bring on record a certain document whereby the Deputy Commissioner, Bracket Revenue, has been requested to keep the Section 8 proceedings under the Meghalaya Transfer of Land Bracket Regulation Act 1971 in abeyance. Stop. Praise allowed. This is a matter for 1 week.
Obliged.
Right.
Item number 5.
May it please the Lordship. My Lord, on the last occasion, I have taken Lordship's permission to take instruction from the corporation whether we'll be relying on the affidavit of the state, my Lord. I mean, the state affidavit, my Lord. So, my Lord, I have forwarded the affidavit of the state to the corporation, my Lord. I have not received any instruction.
Like hide and seek this one.
No, my Lord. Actually, it is also apparently my fault. Due to oversight, I did not know that this matter is coming up today. Otherwise, I would have called them also through telephonic conversation. I would have taken instruction.
When the last
also.
date was?
Last week, my Lord. It came up last week. 1 week time was given, my Lord.
My Lord, I would submit, since they are still considering whether to file. So, the matter may be fixed for hearing. In the meantime, they file.
My Lord, no objection.
Ms. MSR only submits that they are still yet to receive any specific instructions from the corporation in the matter. Matter and praise that the matter taken up on another date. Stop, Ms. Chakravarti's only are submitted that as instructions are awaited, the matter may be listed for hearing and instructions may be obtained in the meanwhile. According to this matter, 23 after 3 weeks for hearing. Yes. On so and so.
Item number 6.
Please, Lordship. We've taken this matter with the government. They're willing to consider this issue of according approval to his candidature. We require a little bit of time.
Candidature for what?
In the select list, his name appears as number 1.
In what post?
Assistant teacher.
Assistant teacher.
Or the one where he signed, who signed, no one
Lordship,
signed?
Lordship. There was a lot of ambiguity with regard to the process. But since the school does not challenge it, we are willing to consider. School, nobody's appeared.
Nobody's appearing.
They've issued notice on 2 occasions, but nobody's appeared.
Mr. SN submits instructions that the case of the petition being actively considered by the state respondents. Just after 2 weeks of waiting outcome, yes.
Highly pledged.
Most blessed, Lordship.
7.
Affidavit?
My Lord, we are still waiting for instruction.
What's the matter about
7 and 8,
My Lord, it was seized without.
What was seized?
This excavator by the police without any seizure memo.
My Lord, this matter is coming for the second time today, my Lord.
My Lord, it is
Otherwise,
nearly
it's,
1 year. It was seized unlawfully. So I pray for a jimma of the articles.
My Lord, the stay is operating also.
MS
On execution of indemnity
submits
bond.
that the affidavit be filed within a period of 2 weeks.
My Lord.
Because machines are getting damaged, my
My
Lord.
Lord, the only instruction which department has given us is to seek further time from this honourable court. Otherwise has not been given till now, my Lord.
Further 2 weeks time allowed to the state respondents to file affidavit. Stop. It is noted that the next date is expected the affidavit be on board. The interim order.
It might be difficult, my Lord, for affidavit to be on board, my Lord. We are still waiting for instruction.
Doesn't matter. Then
I pray for it. On indemnity bond, it can be released.
Yes?
On indemnity bond, it can be released. Money.
We'll take it up. You don't file affidavit, then we'll maybe pass some other orders.
Okay, then interim order may continue, my Lord.
7, 8, my Lord. 7, 8 is a connected matter.
Yes.
Much obliged.
9.
My Lord, in this matter, Lordship has given me opportunity to file my short account rejoinder. We are unable to file, my Lord. If Lordship, unable to obtain instructions. If Lordship give me 2 weeks' time to file my short rejoinder,
Yes.
my Lord.
So we'll take it up today?
My Lord, we are yet to file the short rejoinder, my Lord. So we are seeking.
You don't want to file anymore?
My Lord, we want to file. We are praying for seeking some more time, my Lord. State has filed, my Lord. State has filed.
State
so we want to
always,
give a short
state
response
is
on behalf.
always punctual in filing.
Only matters here appearing. Other matters not appearing is...
That I have now. I will
feel like that.
My lord, I assure that now I will personally monitor all the counters.
And Bharat, you have to be brought back to life.
On YouTube, in fact, I've been asking my GAs also, why have you not filed? What is the problem? Why are you not getting instruction? All those things I'm pursuing it now.
Lordship gave me 10 this time, Lordship.
Mr. H.L. Changreswani, Senior Counsel, submitted due to unavoidable circumstances a short rejoinder to the affidavit of the state respondents on maintainability.
On the race that one
also. It cannot be filed. He prays aloud further 1 week's time for the same. This is thereafter and so on. You'll get more than 10 days, it was 1 week, as per the listing of the Kurma size.
10.
Oh. Close.
Can we close, Lordship?
Mr. Emerald Nongpur, Learned Counsel Petitioner, submits that on receipt of instructions as submitted by Dr. Emerson on the last date, that the matter has been resolved and the petitioners entitled financial upgradation under the ACP/MACP scheme, the matter stands closed.
Your Lordship, would only with all the consequential benefits.
Yes?
With all consequential benefits.
Consequential benefits, if any. Consequential or consequential?
Lordship, since the matter will be placed before the screening board for approval, Lordship, that may be given within a time frame.
Expected, yes. It is closed. Expected the matter be resolved at the earliest, including affording consequential benefits of upgradation to the petitioner.
11.
That has to naturally flow only.
Lordship.
Then, even at earliest, yes.
This matter, we have taken steps on the private respondents also in the earlier occasion, my lord. None of the respondents, including the state, has filed affidavit, my lord.
We seek some time, my lord. The issue is regarding, my lord, the petitioner has filed a writ petition saying that some of the selected candidates in primary schools, they are having diploma of 1.5 years.
Yes, yes.
And their case is that they should have diploma of 2 years.
Some judgments given
by Justice Gawai. Justice Gawai, my lord. This was their 2 judgments which came, my lord, back to back, my lord. So first judgment was with regard to B.Ed recognition, my lord, and second is with regard to diploma. Your lordship has dismissed one case. In second case, what my friend is saying based on the judgment of Justice Gawai is that the requirement as per the petitioner is that the diploma should be of 2 years for direct candidate, my lord. Here what I have learnt, and I have got the documents also showing that all of them have been teaching. And therefore, as per NCT circular and as per Supreme Court judgment of Justice Gawai also,
if they're teaching,
1.5 year diploma is valid.
Yes,
Lord, I will file those documents. That's why I'm taking some time, because I have to place those documents.
It's the Advocate General pays for about 2 weeks' time to file
counter affidavit.
This is thereafter also. Mr. S.A. Sheikh has entered appearance today on behalf of respondents number 11 and 14.
Yeah, Lordship, I was unnecessarily dragging this petition.
You demand cause then, next day, yes.
Let him file affidavit.
Yes, you demand cause.
Oblige.
Yes. That is scheduled trial certificate matter.
Lordship, this was with them was with the pensionary benefits, Lordship, which was not released. Now, with regard to the scheduled trial, we are having in the hearing list, that is item number 38, Lordship. Lordship, last time also I had prayed to be clubbed together, Lordship.
We'll hear it today.
My Lord, in this matter we have not filed affidavit, my Lord. My Lord, what I am praying that both the matters can club together. In the meantime, we will file an affidavit in this also, my Lord. 2 weeks time or 3 weeks time.
What issue is involved? Legal issue is involved, my lord. Because the caste certificate determination, as per the judgment of Supreme Court, my lord, it has to be carried out by the district level scrutiny committee. That Madhuri Patil judgment last time I have given you.
Yes.
As my friend, whenever I'm
Yes, Lordship, and even to that, I have the answer to that also, Lordship. So it has to be done, the hearing, because the hearing has to be on this, Lordship, then only this, the other writ petition, because they're connected matter,
The
Lordship.
second one will be later, or the
Lordship, we can do it on the same, let it be clubbed
The
together,
second one will
Lordship.
come first, my lord.
The
second come first.
Yes,
pensionary
Lordship.
benefit. The second one is 4 or 8 pensionary benefits.
Both are the phrase same, my lord.
When will you file affidavit then?
I've sent for finalization, my lord. 3 weeks time is granted, my lord.
2 weeks, Lordship, because the person, suffering, my client is suffering, Lordship, without pensionary benefits and all.
Everybody is before this court suffering.
Lordship,
Like
then-
they won't come to court if they're not suffering. Yes, MS SK Nongrum, the counsel petitioner. Mr. Dr. M. Mozikala, DSGI, which so and so submits praise that we allowed further time to file the affidavit. Stop. It is noted that this matter is connected to WPC number 276/2023, which is also listed for hearing today. As the matters are interconnected, let's put these matters for hearing on.
And dear Lordship, after 2 weeks.
After 3 weeks, but meanwhile,
My
after,
lord,
after 3 weeks also,
28th or
it is
29th.
expected that the affidavit should be on board before the next date with advance copy to the all the parties is concerned.
Highly obliged.
Hearing, item 13.
Mr. Sengupta is not here, Your Lordship. In fact,
my lord, he's on legs. Catch him, huh?
he wanted, he informed me that he wanted at least 2 days' time. I am also in the same agreement, Your Lordship. There is some latest judgment of the Guwahati High Court on the same subject matter.
Same subject matter. Give the citation.
Your Lordship, since they are asking after 2-3 days, I would like to submit at the same time.
This is a part-heard matter.
Yes, Your
Mr. Vijay Kanta submits that due to, as there's been some developments in law with regard to this, with the issue in question for this court. I forget it. As prayed by the counsel for the parties, this is matter after 1 week.
Your Lordship, 2-3 days, Lordship, possible.
After 1 week. Really difficult.
14.
Yes. After this, how many other matters are done? Notes. Notes. Mr. Sen will take it at 2:15. This matter.
Lordship.
We'll take 2:15. We'll finish it off today. This matter. 2:15. Okay. I'll finish up the other matters. Because today you'll have to conclude, I think.
Even I'll finish. A short reply.
We can't drag it on beyond, you know.
Yes, yes, yes.
It looks.
Yes.
You
15?
don't disappear.
15.
Yes.
Item 15, I may be permitted to withdraw this writ petition, right? With liberty to file a fresh challenging the new tender, if so advised.
In accordance with law.
Yes.
Everything has been in accordance with law. How can you file an illegal affidavit?
Me lot know what they say. With the liberty, court has given liberty because there are ruling. Court has given liberty, so liberty is reserved. So I am entitled. Sometimes limitations, sometimes other issues because they will take the shelter of
Why
the.
is one to post some hearing today?
Yes, my lord, I've been instructed, so I'm.
Mr. Philemon Nonglinear counsel with petitioner praised that due to certain developments, he may be permitted to withdraw this application with liberty to file afresh.
My lord.
If so advised, stop. Accordingly, next paragraph, matter stands closed in withdrawal, however, with liberty as prayed. You led by Dr. Mozika here, no?
Yes, my lord. Deeply.
Why tame retreat like this? Interesting point otherwise.
29.
Yes, Mr. Jha.
My Lord, this is that regularization.
Speaker.
My Lord.
Yes, where were we? What happened?
My Lord,
was it heard before? No.
Yes, it was.
It was.
Yes. Yes, Mr. Jha. Start.
My Lord, the petitioners were serving to the another respondent for last 20-25 years, my Lord.
Oh yes, you said that. Well, because you said that they
are
they are daily wage workers. That's what they stand. That you're not entitled to any privatization. But you say that the other people have been absorbed.
Yes, ma'am.
What somebody situated. Where's that? Let's see. I brought up affidavit.
My Lord, they have filed an additional affidavit to bring on record the appointment letter of the.
Where is that? They have brought on record and additional affidavit bringing on record what? They have filed an affidavit for?
They have filed an additional affidavit, my Lord, whereby they have brought the appointment letters of the petitioners, my Lord.
Where is that?
My Lord.
Filed on? 19/9/23.
My Lord. That is at page 5 annex 1, my Lord.
Tabayaza, Takutania.
My Lord. As far as the petitioners are concerned, my Lord, that is at page 13, 1-3. Annex 2, my Lord.
Yes. Where's your name?
My Lord, one of the petitioners is Bikram Singh, number 2, my Lord.
Okay. The following persons have engaged purely on part-time sweeper cleaners with sweeping so and so and so. Fixed rate of 1,500. Yes.
Part-time.
Your case is that similarly situated people have been given regular appointment.
Earlier.
Then what do you want to show by the earlier one? This is not your affidavit. This is by them. Correct?
My Lord.
We
filed by NIPCO.
By NIPCO. Yes. My Lord, here they are also saying that in response, my Lord, the petitioner has also filed a reply to that, my Lord.
Okay, where's the reply? 19 October.
My Lord.
What do you say in your reply?
In reply, I said that, my Lord, the petitioners are, my Lord, if purely part-time, my Lord. So for the part-time, my Lord, employee pension scheme and other are not deducted, my Lord. I have annexed the Provident Fund annexer, my Lord.
Yes.
If it is Provident Fund is being deducted, my Lord.
Yes.
And CPF, Contributory Provident Fund, are being deducted. So
Yes.
for the part-time, my Lord, it cannot be.
Where is that?
My Lord.
Next year, R1.
Yes, one.
She is also one of the petitioners here. Only one thing, Mr. Jha. Now, after this as per your appointment, you've been paid 1,500 throughout.
As of now, my Lord, only 5,000.
6,500.
Not even minimum wages, Mr.
No, my Lord.
Minimum wages, Lordship, they are paid minimum wages, but for the work of 3 hours.
Okay.
They work for 3 hours. This is a part-time employee, it's purely part-time.
Yes.
My Lord, even for the part-time, my Lord, where is the my lord, they say that for the part-time, and in their own affidavit, my lord, additional affidavit, they have brought, my lord, an extra one with regards to appointment of certain in a regular way, my lord, whereby, my lord, the similar in for the EPF, CPF, if they are the regular, my lord, contributory provident fund are being deducted. So even the case of the petitioner who alleges to be for the part-time for 3 hours as per them, my lord. So for the 3 years, my lord, even for them, CPF, contributory provident fund, are being deducted. And
This lady is one of the petitioners.
Mal. My lord, if I also take to page 13 of the reply, my lord, which we have filed, my lord.
Her name's not here.
Which one, my lord?
The one in lecture, that Smorlin or someone?
No, no, no. They are not the petitioner, my lord.
Then?
My lord, the petitioner is the Gurdeep Singh and others, my lord. They showed that, no, we have engaged, we have appointed them in some of the project, my lord, on a regular basis.
No. You come to this, your affidavit.
Yes, my lord.
Page 8 of your affidavit. Now, what is it? This document shows declaration nomination form, right? Who's this lady then?
She is not the petitioner, my lord, but she is engaged there, my lord.
She is regularly engaged.
She is engaged there, my lord, in the as a cleaner.
Okay, she is also part-time.
As per them, my lord.
No, but what's the relevance of bringing someone else's documents into this in your reply?
My lord, that's I am showing that if the page 13, my lord, if I
of your affidavit
of mine.
Okay. Gurdeep Singh.
Yes, my lord. This is the pension scheme.
Yes.
Our part-time person will be entitled for the pension, my lord.
This provident fund is a pension scheme.
My lord, provident fund, it's a contributory provident funds.
Whatever it is.
In the department, my lord, what happens, my lord? Under the NEPCO, other central government, it's a GPF, my lord. Whereas in the corporation, it's a CPF, contributory provident fund. So contributory provident fund are deducted for the person who is regular member, not part-time or temporary member. Cannot be. So the stand of the respondent cannot be sustainable. Let only part-time having three hours working, that is not sustainable.
Yes, Mr. Jindal.
Lordship.
How long have you been working?
We're working quite for some time. Maybe more than 15.
Why don't you give them some regular employment as a one-off case? Regular, just for them? Like
no,
work charge, let
such
the post die with them when they go?
There is no such post.
You create one.
And we have...
Even running so long and paying them 6,500, who can survive 6,500?
Lordship.
Look at another aspect, forget the legal aspect. If you've taken the service of 20 years
That's what
now.
my Lordship, give me 1 minute time to. Such a order was passed by this court.
Then what happened?
To take up the matter for creation of post. We have taken up the matter. They have said no. For part
Saying no,
time,
very simple.
for part time, it is purely a part time. And your Lordship, remember your own judgment, which you have rendered in my case, where implies.
Don't remember anything. Yes. No,
I'll just read the judgment. I'll just read.
What does the judgment say? This court refuse such prayer.
Yes. 482. WPC 483, 462.
You didn't appeal.
Lordship.
You didn't appeal against this order.
Appellate court has upheld this order. This has acquired finality. With regard to the regularization, your Lordship has also referred one judgment on the basis of which my writ petition wherein I sought regularization, those who are working full time and they were appointed through the selection process. Even then I couldn't get relief or regularization or even for equal wages. And this case, it is more hopeless than the case which your Lordship had.
This is just a mercy case. You see.
And
people are being paid fixed pay also.
Yes,
petition?
yes, they were full-time employees and they were getting fixed salary, and they were working for 15, 20 years, more than 20 years, and their selection process was also.
Yes, you're right. Now I remember. Yes, they were appointed on part-time, on casual basis, part-time also.
Not part-time.
They were paid on daily wage basis, sorry.
Daily wages.
Yes.
Daily wages.
It's in judgment.
This is the judgment.
Let me see it. Yes.
And on the face of this judgment, I find very little scope.
You're correct. You're correct. We can't. Some judicial discipline has to be there. Only because this court feels that 6,000.
No, I do feel your Lordship, but the problem is this: the government, your Lordship, in all department, they have adopted a policy of not giving any regular appointment. Even they are giving on contract only, and they pay because they have to provide. Political thing also. They want to provide the employment to the maximum number of people. What mode they have adopted? Give them appointment for 6 months, 3 months.
No, we've seen that from drivers to
against the regular post. Against the regular post, they are appointing on contract basis only.
That we've seen.
And consolidated salary of 10,000, 15,000. Oh, people need it, and they join. Here in this case, they are working only part-time for 3 hours. After that, they are free.
No, you see the judgment, Mr. Jha. And instead of dismissing it outright, you have satisfactory reading the judgment. Then we'll. Otherwise, your daily wage basis. I was saying that, thinking that if there's any, that only during their tenure, they be given some enhanced pay or something.
Definitely, my lord. Even my lord.
The 6,500 is no one can survive.
That's
there's no question of enhancing the wages.
We are paying strictly in accordance with the.
You're paying with the minimum.
Minimum wages, but for a period of 3 hours.
Correct.
And here, your Lordship,
see, the court's not saying about that. Court's just saying that if there's any avenue, minimum prescribed such doesn't mean you pay minimum only. You can pay them some more. 6,500. You feel sorry for this.
Your Lordship observation will definitely guide them.
And
I will make my endeavors, provided I get some handle from your Lordship.
Because now even Yes, there is, because 6,500 is...
No, I fully understand, Your Lordship, what to do these days. Employment is really becoming a big problem, Your Lordship. And that's why the exploitation is there.
Huge exploitation. But the problem is another flip side is, we've seen from own experience, those who are on contingent or contractual work very well. The moment they regularize, they don't bother to show for work.
That is another factor. And the employer feels more comfortable if they appoint on contract basis, because they are always in fear after 1 year whether it will be extended or not extended.
But once you regularize them,
and this has become the rule of the day. Rule of the day.
You
in all the offices, I am finding that even secretariat also they are appointing on contract basis.
Here also we do the same thing. Anyway, you examine the judgment. I don't think, but only we might pass some observation regard to, let them examine enhancement of wages. And the wages is too sad.
Even the Supreme Court, my lord, I have a judgment that even the daily wages or is part-time, they are entitled for, my lord.
For graduation. You look at the judgment,
my lord.
That's the judgment of this court.
Lordship, other thing I just want to clarify about the provident fund, etc. He was telling. No, these, Your Lordship, we are cutting according to the social legislation.
Yes, it's compulsory.
Even a shopkeeper who's
even
having 20
a laborer, you have to, if you have a ESI and provident fund is...
Yes, it is on that.
Yeah.
So, Your Lordship...
You take, I got the judgment.
Within this week, Your Lordship?
This week?
No, yes, or next week.
Next week, yes. After hearing at some length, Mr. Arjha, please we allowed some time to study the earlier judgment of this court on the same topic. This after, you take the copy of the judgment.
33.
After Lordship?
1 week.
1 week.
Please, Your Lordship. This matter, this is for the promotion from the post of assistant chemist to chemist in the Department of Mining and Geology. There have been earlier rounds of litigations and subsequently it has come to the present writ petition.
Now we are challenging?
Well, the Departmental Promotion Committee had sat, and according to the, I'll just take your Lordship to the previous orders, Milan.
Yes.
My lord, that Annexion 9,
you ready, MS Yangi? You ready?
My friend is ready. I don't know.
Are you ready or not? You're ready, no?
More or less.
More or less.
if your Lordship permits, my lord, this your Lordship is taking up the other matter at 2 o'clock. So this also probably will take a little time. So if it is passed over for the day,
it's over. Or not today?
Passed over for the day, my lord. Because there are other matters coming up at 2 o'clock.
2:15.
Okay.
This will take a little time because certain stands.
What is challenging here? We see it's come to court before.
In the promotion DPC which was held, my lord, as per the earlier direction, in the government had considered he is entitled to be considered for promotion.
Okay.
However, now the DPC which has found him to be
unfit.
Yes, and my lord, on certain grounds, because his earlier regularizations according to the DPC was not proper. Irregular.
Now who's been promoted to this post?
Nobody. Till now, the other person also was not yet eligible, but the DPC has suggested to the government to make him eligible by giving him the regular whatever they have to.
Relaxation.
So, my Our case here is, my lord, that DPC, what the DPC has done, my lord, that is not neither in accordance with the rules and beyond the parameters of the DPC. So we'll try to argue on those lines.
Okay, as on a prayer party, this is matter after 1 week, yes.
36.
All right.
Short matter? No. Lord Mosika, is a short matter or a long matter?
Well, he requires some mistakes because what happened, my lord, he was serving in Assam Rifle and he was sent on deputation to NDRF, my lord. And there he committed some misconduct, my lord. Now penalty has been issued by Assam Rifles. He is challenging that, my lord.
Dr. M. Mosika submits that some instructions are required before the matter is finally heard. Only this is matter after 2 weeks. Are they appearing here also? These boys? No. Yes, ask no.
At 7.
Yes. Yes.
My lord, this matter of the petitioner here, she was working as a professor in the Department of Zoology in Nehu, my lord.
Yes.
So before the COVID had commenced, my lord, she had obtained for leave to go to her hometown, and that leave was sanctioned, my lord. And after her leave was sanctioned, she was working online, and she was working periodically from time to time, whatever the work was assigned to her.
What was the punishment inflicted on her?
My lord, there was no. My lord, what they have done to her was, even though an appeal was filed to her by her, and her leave, her entire period where she was working has been taken as earned leave. So my entire writ petition is for condonation of that leave, my lord. Because once she has been working, and how can the Nehu come and say that this is an unauthorized leave? And there has been no show cause. Nothing has been there, my lord. My lord.
No show cause meaning?
Yes. My lord, if there was an unauthorized leave, my lord, they should have show cause me that there is an unauthorized leave by you from this to this period. There has been no such communication from the Nehu on that regard, my lord. Nehu directly by recommendation of their general counsel had asked me to submit a leave application for the period which I was working, and thereafter they passed an order. After they passed the order, my lord, I gave an appeal that to condone that earned leave, because at that time I had been working online and by conducting classes and the HOD, and I have been reporting to my HOD regularly, my lord. My lord, may I take through the annexures, my lord?
It was through during the COVID time, Lordship.
Yes, my lord. This is during the COVID time, my lord.
Yes, Mr. Sen. We'll take it second half after the other judgment, after the other hearing.
After the other hearing.
Second half?
After the other hearing,
Yes.
My lord.
Second half.
Okay, my lord. Sure. Much obliged, my lord.
Second half is.